We are so pleased to have completed this very considered update to the National Consent Policy 2022 and to be able to share it with you today. This updated policy is now available on our website, hse.ie/National Consent Policy. And this updated policy should help you to bring the provisions and the intention of the Assisted Decision Making Act to life in your day-to-day practice. In today's session, the co-chairs of the National Consent Policy Steering Group, Professor Mary Donnelly from the School of Law in UCC, and Professor Sean O'Keefe, Consultant Geriatrician in Galway University Hospitals, will step through the key updates to the policy. And we really hope that this will be useful as a guide to you when you're reading the policy document. This session is being recorded and will be available on our website as soon as possible. Again, that's hse.ie/National Consent Policy. We'd really like you to send any questions you have based on the information presented today. And we'll try to address any of those questions in an online panel discussion next Monday at 2 o'clock. You can type some questions into the Q&A function during this session, or you can email them to national.consentpolicy@hse.ie after the session. And we'll try and cover those on next Monday, the 29th. So now I'll hand you over to Mary Donnelly. Thank you.
Hello, I'm very pleased to have this chance to provide you with a summary of some of the key updates in the National Consent Policy 2022, and this is now National Consent Policy version 1.2. So I'm going to begin by talking about why it was that we felt the need to update the National Consent Policy. As you know, a new National Consent Policy was published in March of 2022. Now, at that time, we knew that the Assisted Decision Making Capacity Act had been enacted, but it had still not come into force. So while we drafted the National Consent Policy, taking account of the Assisted Decision Making Capacity Act, we could not take all aspects of the Act into consideration because at that time they were not yet in force. On the 26th of April of 2023, the Assisted Decision Making Capacity Act came into force. At that stage, the Act had been amended, so we had two pieces of legislation which came into force on that day. They were the 2015 Act and the Amending Act from 2022. So we needed to update the policy to take account of this new legislation. And that's what we've done with this updated policy. So this is not a new version of the National Consent Policy. It is simply an update to take account of this new legislation. In developing the update, we engaged with key stakeholders, including the HSE Office for Legal Affairs, with legal counsel and with the State Claims Agency. We also in the update incorporated relevant aspects of the Decision Support Services Codes of Practice. It took us a little bit longer than we expected to do the update because it was quite a complex piece of work, but we're very happy that it's now completed. So I'm going to take you through some of the key features of the updates. And this really is to assist you, but you do obviously need to read the updated policy. So this will hopefully assist you and point you in the right direction. So I've put up here the key updates to the policy, and you'll see that they all relate to part 1 of the policy. And that, of course, is because the Assisted Decision Making Capacity Act relates to adults. So the children part of the policy is not impacted at this time. You'll see in red there the parts of the updates that I'm going to focus on today. I'm going to look at the new subsection 4.2, going to look at the changes to section 5 and section 6, and to section 7, and the very minimal changes to section 8. And then my co-chair colleague, Professor Sean O'Keefe, is going to talk about the appendices to the policy. We've added 3 new templates, which we hope will be useful to people in practice, and Sean is going to talk about those. So to begin with the new section 4.2. This is a section, relatively straightforward section, which provides greater clarity on how, as health and social care professionals, you can make information more comprehensible to people, to the people that you're dealing with. This reflects a requirement, a statutory requirement in the Assisted Decision-Making Act, that a person is not to be regarded as unable to understand the information relevant to the intervention if he or she is able to understand an explanation in a way appropriate to his or her circumstances. And we felt that it was necessary to include guidance on how someone can ensure that information is given in an appropriate way for the individual circumstances of the person they're talking to or they're working with. So one of the, and this is done in subsection 4.2. This says things like information should be tailored to the individual's needs. That includes plain English requirements, using diagrams, using videos. But the key point here is that one should always be talking to the person in a way which meets their requirements. So other things in section 4.2, concentrating on core information, breaking down information, pausing to see it's understood, and avoiding medical terminology and jargon. Moving now to section 5, and here you'll see quite a lot of updating done, because of course section 5 of part 1 is about capacity to decide about an intervention. So there are a number of updates here. They change aspects of the way in which people deal with capacity. And in this, we drew quite heavily on the code issued by the Decision Support Service, setting out how to support decision-making and assess capacity. So this is developed very much to be consistent with that code. So we see an incorporation of the ADM definition of capacity. We see the inclusion of the guiding principles from the ADM Act. We see enhanced support requirements, and again, that's a requirement under the ADM Act. Everybody must be supported to make decisions. We see guidance on when a person's capacity should or should not be considered to be in question. You see guidance on when a capacity assessment should be conducted. You'll also see, and here we drew very heavily on the code, the Decision Support Service Code, the inclusion of new requirements for the assessment of capacity. And you'll also see the inclusion of a new duty to support capacity. So in other words, the Act, the Assisted Decision-Making Act, requires that everybody's capacity should be maximised. And that's reflected in the changes made to section 5 of the consent policy. And I just want to identify some of the key points from section 5 to look out for when you're working your way through the policy. Capacity is decision and time specific. That's not new. That was in the old policy, but it's now a statutory requirement. In other words, we don't talk anymore, indeed we haven't for a very long time, about somebody lacking capacity. We talk about them lacking the capacity or having the capacity to make a specific decision at a specific time. Another key point, and again, not new, but reinforced in this update. Persons should always be supported to make the decision before you move to capacity assessment. So support first is the motto, which is very strongly reinforced throughout Section 5 of the policy. Something which I think is new and I think worth spending a bit of time on is a clear guidance as to how you consider whether you need to do a capacity assessment. And what the policy says is that you need to consider what difference a capacity assessment is actually going to make in a particular situation. So, for example, what we have said in the policy is ask if the intervention in question is in accordance with the will and preferences of the person and for the person's benefit. So in other words, you're going to do it regardless of whether they lack capacity or have capacity, because it's in accordance with their will and preference and for their benefit. And we're going to talk a little bit more about that in a moment, some of the aspects of that in respect of Section 6. And if it's not going to make a difference, then you don't need to put them through a capacity assessment. You can proceed on the basis that either they consent and they have capacity, or you are proceeding on the basis of the interventions in accordance with their will and preference and for their benefit. And then the final point to note from Section 5, the final important point to note from Section 5 is the capacity assessment has defined steps. It's quite a formal process. And in this, we draw heavily on the code, the Decision Support Service Code, and we emphasize the importance of documenting the steps taken. So moving on now to Section 6. And we're looking here at the section which relates to making decisions if a person lacks capacity to decide about an intervention. Here the key updates include incorporating the support requirements and the support arrangements from the ADM Act. The Section 6 also incorporates changes to the Mental Health Act of 2001 made by the ADM Act. Section 6 also provides guidance on the role of will and preferences. And will and preferences are very important under the ADM Act because even if a person lacks capacity, their will and preferences are important. They continue to be important, and effect must be given to them if it's possible and practicable to do so. Guidance is also provided on the role of benefit to the person, and that's also a requirement under the ADM Act. Anyone providing an intervention must act in all times for in good faith and for the benefit of the person. So guidance is provided on what that means and how that works. Guidance is also provided on situations where will and preferences, a person's will and preferences are not ascertainable, and how you proceed in those instances. And finally, and importantly, guidance is provided regarding when legal advice should be sought. So I want to move now to some key points from Section 6. And this is an issue which has been of some concern to people in practice, and the policy attempts to state clearly the position. Here we're talking about an intervention in a non-emergency situation where a person lacks capacity to decide about the intervention in question. They don't have a decision support arrangement under the ADM Act, and they're not a ward of court. And the policy is clear that in some circumstances, the policy sets out those circumstances, the intervention may proceed without the need to go to court for court approval. So this is an important clarifying element in the National Consent Policy update. So the intervention may proceed without court approval where it's in accordance with the person's will and preference, it's made in good faith and for the benefit of the person, and everyone who must be consulted under the ADM Act has agreed that the intervention should take place. So the ADM Act sets out a set of people who must be consulted. You'll find that in the general principles of the ADM Act, and obviously replicated in the National Consent Policy. But in those circumstances where it's in accordance with will and preference, it's for the person's benefit, and consultation has taken place, there is no need for court approval. And the policy is clear on that. The policy also addresses the situation where the person's will and preferences cannot be ascertained. And it says that in such circumstances, the intervention can proceed without the need for court approval, where it's clearly for the person's benefit. Anyone who must be consulted under the Act has agreed that the procedure, the intervention should take place, and also any persons who are close to the person, to the relevant person, to the patient in those circumstances, agree that the intervention should take place. So have a look at that part of Section 6, and then note also the circumstances set out in Section 6 where legal advice should be sought. Moving on now to Section 7, and this relates to advanced healthcare plans and advanced healthcare directives. So one of the things which the Assisted Decision Making Capacity Act does, Part 8, makes advanced healthcare directives part of Irish law, gives them a statutory force. So Section 7 incorporates the requirements for advanced healthcare directives. It includes a statement of the duties of healthcare providers in respect of advanced healthcare directives. It gives guidance on how to assess the validity and the applicability of an advanced healthcare directive. And those concepts, validity and applicability, are very important because they determine whether or not an advanced healthcare directive applies in a particular situation. And finally, Section 7 gives guidance on the role of designated healthcare representatives. And finally, we have a couple of minor changes to Section 8. And this is a section which deals with deprivation of liberty. And this issue, which is a very real issue for people, is not addressed in any detail in the Assisted Decision Making Act. And therefore, we have not been able to provide further information based on the Act. There is a new title here. And the other point which we note in Section 8 is that now that new applications for wardship are ceased, that there are no new applications for wardship since the commencement of the new Act, all applications for deprivation of liberty have to go to the High Court using the court's inherent jurisdiction. We simply clarify that point. So I'll finish there now and hand you over to my colleague, my co-chair, Professor Sean O'Keefe. Thank you very much.
Hello, everyone. As Mary has explained, we're going to have new templates which will record the basis on which procedures may occur post-ADM if people lack capacity. But I want to explain first today how we got to that position. You're probably familiar with these 3 tiers that will replace the wardship system. And as we've emphasized many times, these are options to support a person and not mandatory interventions. But how do they relate to healthcare decisions? Well, under ADM, treatment is defined really very broadly. Interventions done for any purpose, for therapeutic, preventative, diagnostic, palliative, or others, including life-sustaining treatment. So it's a very broad definition that covers most things that will occur in a healthcare setting. And how do they interact with the decision support tiers I've mentioned earlier? Well, a decision-making assistant is only an assistant. They won't be making decisions. A co-decision maker can decide jointly with the person if within the scope of the agreement, but otherwise, even if outside the scope, they must be consulted unless it's not appropriate or practicable. A decision-making representative can decide on behalf of the person if within the scope of the agreement, but cannot refuse consent to life-sustaining treatment. But again, even if outside the scope, they must be consulted. An attorney under an enduring power of attorney cannot have any rights to give or refuse consent to treatment, but again, must be consulted. And we have advanced healthcare directives where there'll be a legally binding refusal of treatment if that's valid and applicable and explicitly stated. And a request for treatment must be considered, and it may include appointing a designated healthcare representative who may have the power to consent or to refuse consent if specified. As to the guiding principles, well, these are musts if people's capacity is in question or they lack capacity. And we've highlighted some of the ones that are particularly relevant to healthcare decisions about encouraging and facilitating the person to participate in decisions, taking into account people who are named by the person to be consulted, including decision supporters, acting at all times in good faith and for the benefit of the person, and an intervener may consider the views of others, including those caring for the person. Now, most healthcare decisions are not interventions under the ADM Act if there isn't an existing support arrangement, but the consent policy takes the position that healthcare professionals should act as if the decisions were interventions and apply the guiding principles. So what that means is that we take them into account if they're available, but we consider them if they're not actually an intervention. And there is a long-standing myth of the next of kin consent, and the new policy just develops on the old policy. There's nothing new there, and ADM hasn't abolished next of kin consent, and nobody has authority to give or refuse consent unless they have specific legal authority to do so. And in this case, a person may have formally appointed decision supporters with that legal authority. So if supporters exist, the arrangements must be respected. If there is no decision arrangement in place, then the views of anyone the person asked to be consulted must be considered, even though they're not giving or refusing consent on behalf of the person. And then the views of others may be considered. And the consent policy now advises that they should be consulted. And that's particularly when the person's will and preferences cannot be ascertained. So ADM is not an anti-family or a family excluding law. So to summarise, if somebody needs a treatment decision, such as a procedure, and capacities in question are maybe lacking, then ultimately there may be consent from the person, even if they require assistance to provide that consent. There may be a joint consent from the person and the co-decision maker, if that's within the scope of the arrangement. There may be consent on behalf of the person from a decision-making representative. But if the person can't consent for themselves and there is no relevant decision support arrangement, then consider the guiding principles, and that includes: is the proposed procedure for the overall benefit of the person? Is it consistent with their will and preference if ascertainable? And have you considered the views of those who must be consulted or who may be consulted under the Act? And if everything is aligned, then proceed with the intervention. There will be some circumstances where this doesn't work, and it's not always possible to be exhaustive about where legal advice and considering, for example, putting in place a decision support arrangement would be appropriate and proportionate. But it might be required where there's a conflict between the past and present will and preference of the person, where the choice the person is making seems inconsistent with their known beliefs and values, where the choice they're making involves a disproportionate risk of significant harm in relation to possible benefits, where the intervention is a major one and the proposed treatment carries a risk of significant complications that may have lifelong adverse or life-limiting consequences for patients, or where there is a significant disagreement between those consulted and healthcare professionals regarding will and preference or benefit. And as always, if treatment involves possible coercion or detention, then going to the High Court under inherent jurisdiction will be needed. But we think in the vast majority of cases, it will be possible to use the guiding principles and to ensure that procedures can proceed without the need for legal advice and formal decision support arrangements. Thank you very much.
Thank you, Sean and Mary. We hope that the information presented today will be useful to you as you familiarise yourself with the updated policy document, which still has the year 2022. It's the HSE National Consent Policy 2022 version 1.2 to accommodate those updates. I imagine you may have some questions, or perhaps can think of some case scenarios from your own service which you would like to consider in the context of this update. Please send any of those questions or case scenarios to us at national.consentpolicy@hse.ie, and please send them before close of business on Wednesday, the 24th of January. Next week, we plan to convene a panel to discuss any of those questions arising, including Professor Mary Donnelly, Professor Sean O'Keefe, Dr. Siobhan Vreen, HSE Clinical Director for Integrated Care, Caroline Howarth, Director of Clinical Services for Adults in St. Michael's House, and Joanne Condon, National Director for the National Advocacy Service for People with Disabilities. We'll also have a look next week at the new templates that you will find in appendices 6, 7, and 8 in the updated policy. If you missed any of today's session or had any difficulty with your audio or with the picture, or if you wish to share it with your colleagues, a recording will be available shortly on our website. And you can also register on our website for next Monday's event if you haven't done so already. Again, that website is hse.ie/National Consent Policy. Thanks for joining us this afternoon. I hope you can join us again next Monday. Enjoy the rest of your day. Thank you. Bye.